All right, I think we're ready to get started. Welcome to the spring lecture of the Center for Con Law at Akron. I'm Tracy Thomas. I'm the director of the Con Law Center. The center is one of 4 centers that were established by Congress at the bicentennial of the Constitution in 1986. So we are one of the places, our mission is to do legal research on the Constitution, and we have faculty fellows and students who do research. We offer a minor and a certificate in constitutional law, and we put on programs, including lectures and conferences. So welcome. I have the pleasure of introducing Professor Larry Solum from Georgetown, who is with us today. He is an internationally recognized legal theorist on constitutional theory and procedure. And he has written many articles in thinking about originalism, which will be the topic for today. Professor Solum received his JD from Harvard Law School, his undergraduate degree from UCLA, worked for the law firm of Cravath, Swaine & Moore in New York, and clerked for Judge Norris on the Ninth Circuit. He's taught at Georgetown Law School, as well as the faculties at the University of Illinois, University of San Diego, and Loyola LA. He teaches con law and civil procedure, as well as some seminars. He's published more than 80 articles in pretty much every legal publication that exists. And he's also the editor of the Legal Theory blog, which is also a Twitter and a blog that I follow, and you may know him from that. He also, interestingly, testified in 2017 on originalism at Justice Neil Gorsuch's confirmation hearing, and added to that debate there as well. And finally, he is an accomplished photographer, which is interesting, and this is on his bio, so I need to read this. He wanted to become a law professor at the age of 14 when he began to take the bus after school to the LA County Law Library and read Supreme Court history. So without further ado, welcome to Professor Solum.
Thank you so much, Professor Thomas, and thanks to Dean Peters, an old friend. I feel lucky to have him as my friend. I feel lucky to be able to read his work, and I think you're lucky to have him as your dean. And I would also like to acknowledge Representative Ralph Regula, for whom the lecture is named. He did wonderful things for the University of Akron School of Law, and it's a privilege to be able to give this lecture that recognizes those contributions. So, surprising originalism. And I begin this lecture just by saying that I assume most people think that really there are no surprises about originalism, that we all know pretty much all we need to know about originalism. I think most liberals and progressives believe that it is settled that originalism is a conservative judicial ideology that dresses up reactionary results in the guise of the constitutional text. And I'm sure that many conservatives think that it's obvious that originalism is a necessary corrective to the excesses of Warren Court judicial activism. And I think most people believe they know what originalism is and what the implications would be, and they think they have a pretty good idea as to how originalism would be justified. Well, it may be that you're one of the cognoscenti, that you're into sort of constitutional theory inside baseball. And so what I'm about to say may not come as a surprise to some of the people in the room, but I think most of you are going to be surprised to learn what originalism is as a theory. I think some of you will be surprised to learn about the implications of originalism, just what would happen if we were to have an originalist jurisprudence. And and perhaps you'll be surprised at the reasons why many originalists are in favor of this constitutional philosophy. So I'm going to start with the abstract theoretical stuff first. Originalism is a surprising theory. So even today, in 2018, you still see references to the idea that the core principle of originalism is the doctrine of original intent, and that you can boil that down to one question. What would James Madison do? The basic idea of originalism is to somehow channel the framers of the constitutional text and divine their opinion about some modern case. Samuel Alito, a Supreme Court justice, made exactly this move in an oral argument not so long ago when he was asking what James Madison thought about infrared sensors in the context of the Fourth Amendment, not because he was an originalist, but because he was ridiculing that approach. But that's not what contemporary originalism is. And so here's a surprise. Originalists, almost all, not all, but almost all abandoned the original intent approach in 1986, 32 years ago. So what is originalism then? If the question is not what would James Madison do, what is the right question? What question do originalists ask? So this is a contribution of Justice Antonin Scalia. There are lots of other people who have played a role in this change in originalism. But Justice Scalia, back in the mid-1980s, in a number of speeches, including a very important speech that he gave at the Department of Justice, sort of an informal lunch talk to the Office of Legal Counsel. Justice Scalia said the right question to ask is, what is the public meaning of the constitutional text? What did the words and phrases mean in context at the time they were written? So now there's two parts of this idea. One part is that we are looking for the meaning at the time the words were written. That's important. Lots of words and phrases in the Constitution have changed meaning since the Constitution was first written. A famous example, it was first introduced by a great critic of originalism, Professor Larry Tribe, my con law teacher, and the person who inspired me at age 14 to want to be a constitutional law professor, uses the example of the domestic violence clause in Article 4 of the Constitution. And he points out an obvious fact. Today, if you hear the phrase domestic violence, you almost undoubtedly are thinking of things like spouse abuse, elder abuse, child abuse, that is violence within the family, but that was not the meaning of the phrase in 1787 when the text of Article 4 was drafted. That meaning didn't come into prominence until more than 150 years later, and even then it was a very uncommon meaning. By domestic violence, they meant things like riots and insurrections, and really no one, except one law professor, thinks otherwise. It is a mark of the creativity of legal scholars that you can find one legal scholar who says almost anything, and there's one legal scholar who says that the domestic violence clause is about spouse abuse and authorizes Congress to pass legislation dealing with that subject. Another example, this is my favorite example. The domestic violence language is not misunderstood by anyone. No one except this one guy ever gets that wrong. The surrounding context is sufficient to make it clear that it has nothing to do with spousal abuse. But here's another example where I think almost everyone gets it wrong. So the Seventh Amendment to the United States Constitution, the constitutional right to a jury trial, includes a dollar limitation. The constitutional right to have a jury trial is limited to controversies in the value of greater than $20. So what does dollar mean? What does dollar mean? And I think most of us are pretty sure we know the meaning of the word dollar. I mean, we're pretty much absolutely positive that when the Constitution said $20, it meant this, a Federal Reserve note, right? Paper currency. That's what it meant. In fact, there's a whole student note that's about the problem that $20 was worth a lot more then than it is now. But is that right? Did the word dollar mean Federal Reserve notes in 1791? Now, if you ask the question that way, I think that most of us will realize, hey, there's something that sounds a little bit wrong here. There were no Federal Reserve notes in 1791. They didn't come into being until much later. Paper money, legal tender currency didn't come in the United States until the Civil War. And, now this may be a surprise, there was no dollar issued by the Federal Treasury in 1791. So what did this word dollar mean? It referred to the Spanish silver dollar. Why that? Why did they pick that for the United States Constitution? Well, it's because we didn't have a national currency, and so they chose the unit of currency that was most in use at the time. That was this coin, and they understood the dollar then to refer to a coin with a certain amount of silver. And when Congress did get around to creating dollars, what they first did was to create a silver dollar that instead of a Spanish coin was the United States coin, but with the same silver content. Now that's not very important in and of itself, whether or not the Seventh Amendment means Federal Reserve notes or it refers to a hard unit of currency, the value of which is determined by the value of silver. That has no great constitutional import. But it alerts us to something important, which is that words change their meaning over time. So it's the public meaning, the meaning that the words had at the time. And what does that phrase public meaning refer to? Well, now here's another surprise. You might think, if we want to know the public meaning of the words, what we would do is look at dictionaries from the relevant period. And there are 2 dictionaries. There were magnificent achievements. There's Samuel Johnson's dictionary that's from this period. And then there's Noah Webster's Dictionary of American English. But Samuel Johnson's dictionary is from 1851, decades before the Constitution was written. And Noah Webster's dictionary is from 1828, decades after the Constitution was written. But it's worse than that because it's very clear that Noah Webster knew that the words in the Constitution were figuring in various legal controversies. And so his dictionary reflects opinions about what the Constitution ought to mean. And both dictionaries are basically derived from a very limited sampling of usage, not done scientifically, and rely heavily on the linguistic intuitions of just 2 people. So that's not a really very good way to figure out what the words and phrases mean. And originalists instead today use a technique called corpus linguistics. So what does that fancy terminology mean? Corpus linguistics is the way lexicography is done by people in linguistics departments or by sophisticated dictionary writers. The Oxford Dictionary of American English, for example, is a corpus dictionary. Corpus linguistics is big data lexicography. Databases for contemporary English that include hundreds of millions of instances of usage. And there is a database for the period of the original Constitution. It's called the Corpus of Founding Era American English, and they abbreviate that COFIA. And by using COFIA, we can go to the primary evidence, patterns of usage. We can look at a lot of them, code them, have blind coding by multiple coders, and we're able to identify the relevant range of meanings of a constitutional term. It's a surprise to me to find out about corpus linguistics. Now you might think, well, this is just something that law professors or maybe linguistics professors do. It has nothing to do with the practice of law. But in fact, after a student note was written about this, that was sort of the first thing. Stephen Moritzen, who deserves a lot of credit here. The first big prominent usage of corpus linguistics techniques came not from fancy law professors at fancy law schools. It came from a judge, from Associate Chief Justice Tom Lee of the Utah Supreme Court. It's been used by the Michigan Supreme Court. And it's the subject of intense interest now. But all that corpus linguistics does is tell us what the possible meanings of a word were. It doesn't tell us some things that are equally important, in fact, in many ways more important. Meaning is not just derived from dictionary definitions. It's not derived from conventional semantic meanings. That's what we're getting at when we look a word up in the dictionary or when we do corpus analysis. Meaning is a function of both the semantics and, now jargon, warning, jargon, and what is called pragmatics. Pragmatics is the name that linguistic scholars and philosophers of language give to the role that context plays in the production of meaning. So the first thing context does is disambiguates. Almost every word, it may be every word. I have a research assistant who worked on this, and I think it's every word in the Constitution has multiple senses. How do we know which sense is the relevant sense? When there is ambiguity, how do we disambiguate? We disambiguate usually by context, by looking at surrounding words, by looking at the occasion on which the words were uttered, right, and figuring out, given that context, which meaning was the salient or relevant meaning. But context does something more. And another surprise, right? I just knew nothing about this before I started doing research as part of the project of figuring out how originalism might have a rigorous methodology. Context also enriches meaning. That is, it makes meanings that are very sparse, spare, richer, fuller. And I'm going to talk about the way that happens. So here's one way it happens. I'm going to give the most famous example of what's called pragmatic enrichment from this jargon, pragmatics as the study of context. Most famous example of pragmatic enrichment was come up by the guy who came up with it was a philosopher. I've just tweaked the example a little bit. I write a letter of recommendation for a student. And here is what the letter says. It says, Ms. Powers attended class regularly, and she was always punctual. I recommend her, period, signed Lawrence B. Solum. Now, the semantic meaning of that letter is very limited. It says she was punctual and that she attended class regularly. But as a letter of recommendation for a lawyer, say for a Supreme Court clerk, it's like the worst possible letter you can write. Because there is a context here. Letters of recommendation, we know, are supposed to convey the best stuff that you know about the person you are recommending. If the best you can say about a potential Supreme Court clerk is they attended class regularly and they were always punctual, that conveys the message, this person is terrible, do not hire them. There's another piece of jargon here. That's called implicature. A word that was made up by the philosopher Paul Grice, who first started to identify and theorize this phenomenon. Here's another form of pragmatic enrichment, presupposition, and now I'm going to give a legal example. The Ninth Amendment to the United States Constitution says, the enumeration of certain rights in this Constitution shall not be construed so as to deny or disparage others retained by the people. Others retained by the people. The Ninth Amendment does not say that there are any such others retained by the people. Right? It doesn't say that explicitly. And in fact, there are judges and law professors who picked up on that fact and said, well, the Ninth Amendment doesn't say there are rights retained by the people. There are no rights retained by the people. They just put this in there for no reason, right? Sounded good. But that makes no sense. The Ninth Amendment has a presupposition. This is, again, a technical term. The Ninth Amendment presupposes that there are rights retained by the people. It communicates that idea, even though it does not say it explicitly. Here's another example. This is something that is called impliciture. We have another name for it too. Sometimes it's called ellipses. These are words that are implicit in what is said, but that are left out. And you get them from context. So I'm going to give a non-legal example. Jack and Jill are married. Impliciture to each other. Jack and Jill are married. Normally, not always, you can cancel it. Jack and Jill are married normally conveys the additional content to each other. The Constitution is full of implicitures, as are most statutes. For example, most provisions in the United States Constitution only apply in the United States. Lots of statements in the Constitution are written so that literally they apply to the whole universe. But we understand the impliciture, the implicit statement in the United States to be all over the Constitution, except lawyers, when it is to their advantage, sometimes say it doesn't say in the United States, and so this amendment to the Constitution applies in Spain. They're erasing the impliciture by going back to the pure semantic meaning without the contextual enrichment. Okay, enough theory. That was a lot of theory. Enough theory. Let me talk about implications. Originalism has some surprising implications. Now, again, if you're in with the in crowd, you may have heard some of this already. But most law students and most American law professors and most lawyers and judges and even some Supreme Court justices have not heard a good deal of what I'm about to say. Let me just start with Brown v. Board. Because Brown v. Board is frequently argued as a basis for opposition to originalism. Those people who wrote the 14th Amendment, they were also the same people who segregated the schools in the District of Columbia, and therefore Brown v. Board would have come out the other way if it had been decided on originalist grounds. Now, I don't know of any originalist who thinks that. Professor Michael McConnell of Stanford University, formerly a judge on the United States Court of Appeal, wrote a magnificent article that in my mind shows pretty much conclusively, although there is debate about this, that Brown v. Board would have come out the same way under the original meaning, but not of the Equal Protection Clause. If someone wants to ask about that in questions, I'll talk about that clause. Under a different clause, the Privileges or Immunities Clause. And in fact, a majority of Congress voted to prohibit segregation of schools on the basis of what they believed their power, under the Privileges or Immunities Clause and pursuant to Section 5 of the 14th Amendment. And that would have become law, except that at the time, the House of Representatives was a lot more like the Senate is today, and you needed a supermajority to get legislation through. And so it got a majority vote, but not a supermajority vote. They believed that the Privileges or Immunities Clause, which guarantees that the basic privileges, the basic rights, the basic liberties, the basic benefits provided by government must be provided to all citizens. You can't pick and choose. The Privileges or Immunities Clause was written out of the Constitution by a living constitutionalist Supreme Court. Famously, in the slaughterhouse cases, these are cases that are sometimes studied in the basic con law course, and later in a little bit less famous of a case, the Cruikshank case, the Supreme Court basically said the Privileges or Immunities Clause has no meaning. Now, they didn't say no meaning. They said there are some privileges or immunities. I love this list. This list is just so great. Here's a privilege or immunity that was so important we put it into the Constitution according to the Slaughterhouse Court. States should not be able to send the state navy to help pirates against the United States Navy on the high seas. That's one of the privileges or immunities. What else can't states do? They can't send the state militia to Paris to prevent American citizens from accessing the American embassy. They had a very, very narrow understanding of what constituted a privilege or immunity. What if the Privilege or Immunities Clause had been interpreted by its original meaning? It would have had profound implications. I just want to talk about one of those, the implications for gender equality jurisprudence. Now, you may be saying, what? Gender equality? That wasn't a 19th century idea that animated the framers of the 14th Amendment. That wasn't their original intent. That's right. They were not trying to establish gender equality. But they did write language that clearly applies to both men and women. The Privileges or Immunities Clause applies to all citizens. Women then, as now, were citizens. Now you might ask, okay, women get the privileges or immunities of citizens of the United States. What does that have to do with gender equality? Well, think about Bradwell versus Illinois, an infamous case, right? A case that said that the state of Illinois could deny to Myra Bradwell admission to the bar. Now, the majority in Bradwell versus Illinois said, well, the Privileges or Immunities Clause, the basis for Myra Bradwell's legal theory, it doesn't mean anything except this little tiny list of very peculiar rights. And so it has no relevance here. But Justice Salmon Chase thought otherwise, and he dissented. Now, he didn't write an opinion. He was very sick. But I think we know what he would have said, right? The right to practice a lawful profession is one of the basic rights protected by the Privileges or Immunities Clause. That's very close to what the dissenters, including Chase, said in the slaughterhouse cases. So women have a right to engage in a lawful profession. Now you might ask, well, why was it that some other justices who dissented in Slaughterhouse did not agree with Justice Chase? And that was because, and they wrote an opinion to this effect. You may have read this opinion, really one of the Supreme Court's worst moments, that women just are incapable of being lawyers. Women can't be lawyers. Now, they didn't say Myra Bradwell couldn't be a lawyer. They said, now, there may be an occasional freak a woman capable of being a lawyer, but the law does not have to take that into account. It's so rare, so out of the ordinary, that the law can treat women like children. Children can't be lawyers either, even though they are citizens. So the court got the facts wrong. They got the facts wrong, right? You have to be reasonably enlightened in the mid to late mid-19th century to know that women could be lawyers, right? They got the facts wrong. But under the theory of the original meaning, the theory of the dissenters in the Slaughterhouse cases, once we got the facts right, then the 14th Amendment privileges or immunities clause is a guarantee of gender equality. And when is it in American history that the legal system had made the transition on this issue? And I would say that when the Constitution was amended to give women the right to vote, that's the point at which the law would have changed to reflect the new understanding of the facts. In the 1920s, 50 years before the Supreme Court's gender equality decisions in the 1970s. Let me give you one more example of a surprising implication. So I've already talked about the Seventh Amendment. It has two clauses: the preservation clause, the right to jury trial at common law shall be preserved, right? And then the $20 limitation. And then the re-examination clause: no fact tried to a jury shall be re-examined other than by the procedures of the common law. The original meaning of the Seventh Amendment started to disappear, started to be eroded by living constitutionalist decisions in the 19th century. In the 19th century, judges started to say that judges have a lot of power. Not really a big surprise. And they started taking power away from juries. Now, what relevance does this have today? I want to give an example. Now, you have to kind of be either a law student who's taken civil procedure or a lawyer who knows something about civil procedure to understand how sort of important this example is. So many of you will have heard of the Supreme Court's decisions in Twombly and Iqbal, right? Every first-year civil procedure class talks about these decisions. And if your civil procedure teacher is like every other civil procedure teacher who I've ever heard of, you probably learned that Twombly and Iqbal are an abomination, right? What do? They give judges the power to make decisions about the facts of a case at the pleading stage, to decide whether the factual theory of the plaintiff is, quote, plausible. And that's pretty much completely inconsistent with the Seventh Amendment. At common law, no plausibility decisions could be made at the demurrer stage. Everything had to be accepted as true. So now, those are very conservative decisions. Twombly and Iqbal, they're probably the two most important conservative procedure decisions of the last 10 years, but they would not survive an originalist analysis. And I can go on and on. I have a million of them, not literally. I've got a dozen or two of these examples of very important topics where the original meaning is surprising and it would be welcome by many progressives and liberals. But I have to confess that not all original meaning arguments lead to progressive results. There are an equal number, or a greater number perhaps, of issues where the original meaning leads to a result favored by conservatives. Right? It's a mixed bag. But I think that for many Americans, for many law professors, for many lawyers and judges and law students, the idea that originalism frequently leads to outcomes that are not embraced on policy grounds or ideological grounds by conservatives, that are opposed by many conservatives, will come as a surprise. Okay, surprising theory, surprising implications, and now my third topic, surprising justifications. Now, I think that most people would say, well, many law professors would say there is no justification for originalism. And then they might say something like, and the people who try to justify it really they're against judicial activism. And the excesses of the Warren Court, that's the real justification for originalism. And what I want to suggest is that, in fact, the core justifications for originalism ought to be persuasive to everyone who values the rule of law and democratic legitimacy, irrespective of your political orientation. Now, here's how I want to get at this idea. What's the alternative to originalism? Well, originalism is the idea that we have this fixed meaning. We look at the meaning of the words at the time, and then that meaning is binding, it's constraining. Judges have to respect that meaning. If you haven't been to law school, that might sound like it's obviously true. And many law students think it's obviously true, or something like it in the very beginning of con law, especially if they take it as a first-year course. But in law school, we learned that that's just not right, that the constraining part is just not right, that the constitutional text should not operate as a hard constraint on what judges should do. And sometimes we call this view living constitutionalism. But what I would like to suggest is that living constitutionalism, which has done much good, many living constitutionalist decisions that I think are good decisions, decisions whose outcomes I approve of, living constitutionalism is very dangerous. Why? Well, because you can dress up what the Supreme Court does in the language of interpretation. You can say the Supreme Court is not making political decisions, it's interpreting the law. It's just that interpretation is a complex activity, and the words are not the only factor. The political context, policy, many things must be taken into account. But the reality is that once you take the lid off, once the constitutional text is no longer binding, once judges are required, in fact, to take their views about what good outcomes are, what good policy is, what they believe justice requires, into account when they make constitutional decisions, then pretty soon, this might take a decade or two, but in the long run, historically, pretty soon, political actors are going to figure that out. you can only keep it a secret for so long. And once the political system has figured this out, it is inevitably going to lead to the politicization of the judicial selection process. And anyone who's followed judicial selection in the United States at the federal level in recent years knows that it has become highly politicized. The hearings over Neil Gorsuch, for example, the Democratic strategy, they decided not to go after originalism. I was sort of irrelevant there testifying about originalism because they had made the decision that the hearing should be about the question, on whose side will Justice Gorsuch be? Will he be for the little guy, for employees, for consumers, or will he be on the side of big business and so forth? Well, think about that, right? The United States Senate is starting to see the judicial selection process as a competition to get judges with particular political views on the Supreme Court. And it's not, I don't mean to suggest in any way that Republicans aren't doing the same thing. They clearly are. More focus on originalism, but still, lots of concern about politics. There's no question about it. Well, in my opinion, what we are in now is a downward spiral of politicization. The judicial selection process and the Supreme Court itself becomes more political with time. Partly that's tit for tat. Right? You did this to Bork, so we're going to do that to Judge Merrick Garland. Right? Part of it's tit for tat, and there are many other causes as well, right? But where does a downward spiral of politicization end? What would a thoroughly politicized Supreme Court look like? And what I would like to suggest is that that is not a pretty picture. We can get some idea of what a thoroughly politicized judiciary looks at by examining most of the nations of the world. A rule of law judiciary is a relatively rare thing, with somewhere between, say, 25 and 40 countries having judiciaries that are not thoroughly politicized. A thoroughly politicized judiciary is a judiciary in which who wins, not just in the Supreme Court, but in every court, depends on politics. The plaintiff is strongly associated with my party, they win. The defendant, in this case, they are associated with a political clique that did not support me, so they lose. A thoroughly politicized judiciary is dangerous to all of the benefits of the rule of law, which is a fundamental protector of individual liberty, of the ability of our economic system to function, of our political rights to vote and participate in the political process, and everything else that the law protects. So I don't think I'll have convinced anyone. Right? Almost no one could be convinced by a lecture or a law review article or even a whole set of books with arguments about this topic. But here is what I do hope. Here is what I do hope. I hope that you were surprised. And I hope that those surprises might lead you to think, maybe I should take another look at some of these issues. Maybe originalism is not exactly what I thought. Maybe originalism doesn't have exactly the implications that I always believed. Maybe the reasons to be an originalist are not the reasons that I've already rejected. Right? If I've surprised you, then I've done my job. Thank you very much. So I think we're supposed to end at 5 o'clock, but that gives us a few minutes. We started late, and I took my full 45 minutes, but we have some time for questions.
So I'm just curious, from a public meeting standpoint, how would you approach a word that appears in, say, a later amendment that also appears in an earlier amendment or the original text? So say liberty in the 14th Amendment versus the 5th Amendment. There's many decades between that. What time frame should you be looking at, and is there a role for intent in making that decision?
Yes, so I'm going to repeat the question because we're streaming and recording. So the question is, what do we do about language that appears in the Constitution more than once and where the occurrences are separated significantly in time? So I'm going to use a slightly different example. I'm going to just talk about religious liberty, which is in the First Amendment, and then on a conventional understanding of the Privileges or Immunities Clause, one of the things it does is to, the word we use as lawyers is incorporate, is to guarantee the rights in the Bill of Rights as part of this larger set of basic rights. And the Establishment Clause had changed significantly, for example, between the time when the First Amendment was written and the time at which the 14th Amendment was written. Here's how big the change was. We're kind of familiar with the later view because it's closer to our view. The original First Amendment Establishment Clause could have easily been paraphrased as, I love it, now I get to say this word, as the anti-disestablishmentarianism clause. The authors of the clause were just as concerned about preventing Congress from interfering with state multiple establishments. So, you know, in Massachusetts, when the Constitution was ratified, you had to support some religion by a tax, but multiple religions. It was a multiple establishment. Well, by the time that started to disappear shortly, it was already on its way out, and it had disappeared long before the 14th Amendment, by which time the Establishment Clause had a new meaning closer to our meaning, right? So my view is that when you have words that appear in two places and their meaning has changed, if the meaning of the words has changed, if the content communicated has changed, although the words look the same, then you're in this position that the Establishment Clause for an originalist might mean one thing in the First Amendment and a different thing as incorporated in the 14th. Or that liberty, I don't think there was a change with liberty, property, or life. I'm sure that the meaning of the word life had not changed in between the two due process clauses. But if it had changed, then the original public meaning of the two clauses would be different. Yes, CJ.
Professor Solum.
Dean.
And I think that perhaps my voice is getting picked up, so you can feel free to repeat this if you want. But hopefully this little microphone phone thing is picking it up. So I wanted to focus a little bit, ask you to focus a little bit on the question. I guess one way to phrase the question is, what is the proper unit of original public meaning? So I'm thinking of an example here. In Heller, District of Columbia versus Heller, which, as many of you know, is the decision where the Supreme Court really for the first time held that there was an individual right of some sort to their arms that was not connected to service of the Justice Scalia, who wrote that opinion, took what he professed to be an original public meaning approach. And I think a lot of people, including myself, thought it was a little bit odd the way he executed it, because he sort of put aside the preamble. So the Second Amendment reads as follows. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed. And what Justice Scalia did in that opinion is he kind of put aside that so-called prefatory clause, or the preamble, a well-regulated militia being necessary to the security of a free state, and he focused on right of the people to keep and bear arms. And he came up with what he believed was historically an accurate description of what the original public meaning of that phrase was. And then he went back and he sort of checked it or cross-referenced it against the possible meaning of the prefatory clause to make sure there was no inherent conflict. I thought that was strange because I thought it made at least as much sense to sort of start with the prefatory clause as a way of, if you will, maybe it's a way of giving context to the operative clause, as Justice Scalia. To me, that raises the question of what is the unit that we're looking at? Are we looking at particular words like right, keep and bear and arm, people? Or are we looking at something larger than that might require us to take into account things like dependent clauses and so on and so forth? That has always, to me, been a mystery about original public meaning, originalism. I wonder if you could talk about that.
Yeah, all day.
Or at least in 5 minutes.
But in 2 or 3 minutes, I can say some things that I think are important. In the abstract, of course, we're always concerned with the whole Constitution, right? You have to look at the whole Constitution because every clause in the Constitution could be affected by other parts of the Constitution. And if you're looking at a part of the Constitution from a particular period in time, anything that was written at the same time is part of the context that was communicated, so that's relevant. But that doesn't mean that you only look at the whole thing all at once. The Constitution is not one big, long, primal scream that the meaning of which is just the entire whole thing. The whole is important, but so are all of the parts. Now, with respect to the Second Amendment, there are these 2 clauses. Now, even Justice Scalia, who identified a prefatory clause and what he called the operative clause, believed that the prefatory clause had to be taken into account when reading the operative clause. He thought, his theory was, the prefatory clause is like a preamble in a statute. It's stating it's unusual in the Constitution for individual clauses to have their own preambles. There is a big preamble at the top. There are some clauses, the intellectual property clause, that state their purpose, right, to promote the progress of science and the useful arts. But it's unusual. But he thought it was a preface followed by an operative clause, and that whatever interpretation you gave to the operative clause must be consistent with that purpose. And he had an elaborate theory as to why it was that the militia purpose was consistent with the federalizing of what he thought was a pre-existing legal right to bear arms. Justice Stevens' theory was different. The relationship between the two clauses was different. Justice Stevens thought that the clause could be paraphrased as the right of citizens to bear arms shall not be infringed in ways that would impair the efficacy of the militia protecting a free state. So that the prefatory clause was an implied scope limitation. It wasn't stated that way, but he thought it would have been understood as an implied, or the intent. He was really an original intent guy on this one occasion, right? The intent was for it to operate as a limitation on the scope of the right. Now, there's a linguistics professor who's written about this. And I don't know whether his argument is right or wrong. I have no idea. I just know that he said this. He says that the grammatical form of the Second Amendment was very common at the time. And here would be the paraphrase. So long as it is the case that a militia is necessary for the defense of free states, so long as that condition holds, he thinks that ing form operates in this way. So long as it's the case, that's the way we'd say it now, then the right of the people to bear arms shall not be impaired. But if it should ever be the case that we don't need militias anymore, then the right vanishes, right? Now, I think this is an empirical question. Right? It's an empirical question. Which of these three interpretations is correct? And, you know, you have to marshal the evidence. People frequently say about this case, Scalia looks at originalism and says that there is an individual right to bear arms. Stevens looks at originalism and says there is not, but that's just not right. They were using completely different versions of originalism. Ironically, Justice Stevens, who I'm sure fully agrees with all the critiques of original intent originalism, used original intent analysis. He was not asking the meaning of the language. He was asking basically what goal was the language attempting to achieve. And his conclusion is that the goal, Scalia would not disagree with this, that the basic goal of the amendment was given by the prefatory clause. That was their basic goal. That was the central purpose of the amendment. And then he says, so the operative clause is not legally binding. The goal is legally binding. That's the original intent of the framers. So it does show that you can get to very different results on original meaning analysis and original intent analysis. And you'll notice I've sort of deftly evaded the question as to exactly what the relationship is, because I don't know. I haven't read the evidence, and I've only read like a handful of articles that marshal the evidence. And many of them were written quite a long time ago, before sophisticated originalists were really pursuing public meaning in a rigorous way. Do we have time for one more or not? Because we're...
That might be the end of our time.
Okay, thank you.